Hello everybody, welcome to the second half of the contracts essay approach. I'm going to give you a moment, as I did in the first half, to copy down this checklist, and I'll be back in a few to continue. Okay, hopefully that gave you enough time to copy that down. Now I know the board looks a little bit more scant than the first half of the contracts approach, but there's still a lot here and there's still opportunity to miss a lot of key issues. But before I go into steps 4 through 7 of a contracts essay, I want to first kind of give you an overview of where we're at. So as you remember from part 1, I gave you 2 initial scenarios after step 1, applicable law. And those scenarios were that scenario 1, the facts told you that formation had been met, valid contract, written contract, therefore you quickly established formation, you got out of it, maybe touched upon the statute of frauds a little bit, and you're going to end up here at step 4. Regardless, if you have gone through a full-blown formation essay, you still have ended up, here at step 4. Now, if you were in scenario 2, where the facts and the calls of the question really required a full-blown formation discussion, then usually the issues in step 4 and 5, are not as meaty in your fact pattern. However, you still want to be on the lookout perhaps for a few of them. Why do we end up here? What happens? Well, think about contracts in general. I don't know if you've ever been into a contract relationship with somebody or another party, but the key is usually the terms that are agreed to in what I call contract 1. Contract 1 was everything that we did in the first half of the contracts approach, that first video. Everything and every term agreed to in that first contract usually doesn't get upheld by one party or the other. So what that means is, at the beginning of step 4, I want you to ask yourself, what terms do we have right now? What terms in their agreement? Based on a few things. So let's look at this kind of, I gave a little factual chronology here, just some made up facts. Actually, these facts are based on an essay from the California bar exam from February 2010. And they give you a number of facts where I want you, if you ever have a sequence or a chronology of something that has gone on in your fact pattern, like date of contract, date of delivery, maybe a condition time of the essence provision, I want you to map it out as follows. But why I'm doing this is because usually in the world of contracts and in agreements that people enter into, we don't end up in litigation and we don't end up in breach, which is ultimately what's going to happen here, right? If everything got done pursuant to the initial agreement, you wouldn't end up in breach. There wouldn't be a potential breach of contract action, which is what they're testing you on in these contract essays. But why do we end up at step 4? We end up there because something in the initial agreement likely has been changed, potentially. And it is your determination in your lawyerly thinking cap that is going to have to argue or not as to whether or not the date of delivery was agreed to be changed, whether or not the dress that was supposed to be made with French lace can now be made with satin, whether that was really a legal valid change. Is there something that an attorney can argue for one or more parties where there is a legal basis of a modification or a waiver or an estoppel? And if there is not, just bear with me as, we'll go through this, but I want you to not just think of everything so methodically. I want you to really put on that lawyer hat, because the California State Bar, and if that's what you're taking, is a lawyerly standard for the writing. So you've got to think, okay, I have this contract that's been formed, but what has happened since formation? The good news is, as you're going down the chronology of your fact pattern, usually there's the formation and applicable law in the beginning, and now you have found yourself either directly in breach, which means steps 4 and 5 and the issues contained therein are not really relevant, or there's something else that has happened. And definitely if you are in a common law agreement, this does happen, and the scenario happens a lot, and it is very repetitive. But even if you are in a UCC agreement, these issues do apply as well. So let's go through them. But first I just want to kind of go over what my terms are in this mock agreement that I have. So I have date of contract April 1st. What do the parties agree to? Well, we have a corporation that has hired a computer programmer to create 4 custom computer programs, and they want them delivered by May 15th. They want them delivered by May 15th. That's all I want you to know for now. So let's say that those terms were established in formation. That's where we had those terms established, and we're going out of the contract now. We have formed the agreement, and we're saying to ourselves, step 4, has anything been changed potentially? Does one party want to argue that a change occurred? Okay, has anything been modified or altered? So what are we looking to? Well, first we're going to see, do we have any conditions in that first agreement? And if we did, we're going to just merely identify the condition. When you're labeling a condition, there's no real argument. I don't want you to talk about whether or not the condition has been breached at this point. I just want you to identify the condition. So in our example, we have 4 computer programs by May 15th. This is an express time of the essence provision. It's an express condition precedent, and that needs to occur because we have a strictly construed deadline, May 15th. So you're going to identify that as a condition. Now I want you to keep in mind, there are no issues here for the most part that I can ever tell you will always be at issue. This is where your issue spotting is going to severely come into play. So you have to be able to identify that's a condition. You have to then be able to identify that's a merger clause. Why do we care about a merger clause? A merger clause is language that basically says the agreement, the contractual agreement, and the terms within it are the only terms that are valid. Nothing that was discussed before or nothing after the formation of that agreement can come in to prove a change, or can come in to prove a modification, or that something else was meant. So if you ever see a merger clause, I want you to identify that you have a merger clause. Again, conditions and a merger clause, you're merely identifying that you have them. Now, the parole evidence rule is incited by a merger clause, and it's merely an evidentiary standard. Let's look at the rule together. Parole evidence prevents the introduction of prior written or oral and contemporaneous oral expressions that contradict, modify, or vary contractual terms and are inadmissible if the written contract is intended to be a complete and final expression of the parties. Well, of course, if we have a merger clause, then yes, the intention was that the terms were the final and complete intentions of the party, and therefore, per the parole evidence rule, that evidence of anything prior will be excluded. So this is merely the examiners wanting you to know that a merger clause, separate IRACs for both, would incite the parole evidence rule. But don't spend too much time here. Now, perhaps one of the sequence or one of the communications post-formation is a potential modification. What does that mean? Okay, let's go to our example. We have 4 computer programs to be delivered by May 15th. Let's say Sally receives a call. Let's say Sally is the representative of the company waiting on these computer programs. Sally receives a call from computer programmer about, April 10th, like I have here on my little fact pattern. And what does the computer programmer say? I'm so sorry, something's come up. I can only get you 2 of the computer programs by May 15th, and the other ones I can get you by May 20th. The other two I can get you by May 20th. And that call, again, that happens on April 10th. Sally responds, hypothetically, okay, I guess I'll have to live with that. So as you're going down the sequence of your facts, this is the first conversation in step 4 that has taken place. Well, what are we going to do with this information? First, we're going to identify, wait, we had a condition here. The condition was delivery by May 15th. We also maybe potentially had a merger clause that said these are the final terms of the parties. Well, why do we care about that? Because one party is probably going to say, no, we modified, or we talked about maybe having an extension on the delivery date. No, parole evidence is not going to let it in. Now, there are exceptions to the parole evidence rule that you should know, so make sure that you identify those as well as where parole evidence can come in. But the more relevant part, pursuant to my example, is a modification, a potential modification of that condition, that delivery date, okay, that time of the essence provision. And Sally's saying, I guess I'll have to live with that. In my example, we're in a common law contract. Well, for a valid modification, we need additional consideration. Let's assume that the facts did not give any additional consideration. Maybe they did, maybe they didn't. That's where your analysis is relevant. That's where you're going to have to conclude that there was no valid modification. Even if you see right off the bat a modification did not take place, make sure you still identify it. Modification is one of the most missed issues on a contracts essay. So make sure that you know how to identify the issue of a modification. Anytime you see a potential change, and that's why make a little outline on your scratch paper on the corner of the fact pattern of the initial formation terms. And any communication, whether oral or in writing, an email, a text, okay, that says, I want to change one or more of those terms, modification should be on your radar right away. Okay, right away should be on your radar. And that goes for both UCC and common law contracts. Under the UCC, we just need good faith effort to modify. Now, if you don't have a modification, I'm going to skip these two issues for a moment and go to waiver. Waiver is another issue that tends to cluster, tends to also be tested along with a modification, because as lawyers, we're thinking to ourselves, okay, let's just say we're representing the computer programmer and inevitably there's a breach because Sally's gonna, what is she gonna do? She's gonna reject all of the computer programs, and as I said here on April 12th, she's gonna hire someone else. She's had it with our initial computer programmer. Well, the computer programmer is gonna go hire a lawyer. Pretend you are that lawyer in the call of the question that they wanna hear from you, okay? And what do they wanna know? Well, they wanna know, did Sally agree to the 2 other computer programs being delivered past May 15th? Did she agree? So first you're gonna, again, write modification, potentially, right? Let's say there's no additional consideration, don't stop there. As lawyers, we're looking for any legal ground to argue that there was a change. So then you're gonna say, oh, well, maybe that was a waiver. So if it's not a modification, all hope is not lost. It still could be a waiver, okay? Or maybe there are estoppel grounds. So I want you to really pay attention to estoppel, waiver, and modification, especially in common law type contracts, okay? They almost will always be at issue when the latter half of the contract is what's really significant for your facts and calls of question. Other issues that could come up that would determine a change in the initial formation, accord and satisfaction, and novation. Those are also hot topics. Make sure you know how to identify them. This is your main checklist for step 4. Now I want to add that a modification, let's say the initial contract did not need to be in writing under the statute of frauds. As modified, it might need to now fall under the statute. So make sure you would add that to your rules section for the modification. And even if modification has been met, if the statute of frauds is not met, it is not a valid modification unless, again, an exception to the statute of frauds applies. So this could be a real big issue, and sometimes modification is a very big issue. Okay, so you want to determine next, have there been any changes? These are your main sequence of issues. Now, you've probably seen a lot of these issues scattered across different parts of a contract's outline. please trust me when I say that this is the best way to have this checklist down in your mind, because for instance, if you're putting waiver in discharge or performance, it's just going to confuse you. Now, another thing to keep in mind, these issues can be out of order. There's no exact sequence that these issues should be in for step 4. However, I do think that having merger clause and then the parole evidence rule as it incites the parole evidence rule is the best sequence for it. Other than that, you can kind of play around. Now, also keep in mind with modification, you can have 2 parts of the initial agreement that potentially are trying to be modified. So let's say it wasn't only the date of delivery that they wanted to modify, the computer programmer wanted to modify, but also he didn't have the exact program they talked about and he wanted to make a change in the program. You would have 2 separate sections for modification. One, you can even label it. They love labeling, okay? Be very clear. Modification of computer program, rule analysis conclusion. 2, modification of delivery date, and then rule analysis conclusion. But make sure that any potential change, other issues that go into each potential modification, to be clear, let me actually just reiterate this. Let's say you're in a modification of the computer program. You IRAC it and you conclude, yes, there was a modification. And then regarding the computer program, you also see there was a waiver communication. Then do waiver and IRAC it right there under that same section of change to computer program. Then go and deal with change to delivery date separately. Don't clump it all together for structure purposes. Okay. So we have gone applicable law, step 1. I always like to reiterate to really hit it home. Number 2, formation, 2 potential scenarios. Number 3, defenses to formation. And number 4, any changes, any material changes to the contract. Be careful here, because by the time you get out of step 4, you really should be able to determine what terms per the entire agreement are we left with here? What has not changed since the initial formation? And what do we have a potential legal basis to argue where a change did occur? Okay? So as you get out of step 4, you are now in step 5, and that is excuses to non-performance. Let's actually look at step 5 together on your approach. At this point, the complete terms between the parties have been identified. The question remains, has either party failed to perform one or more of these terms? If they have, is there a legal excuse that would support the party not performing their end of the bargain? So even though we have our terms, have the parties perform the terms? Did the computer programmer deliver all 4 programs or only 2? And if he or she did not deliver all 4, was there an excuse to that non-performance? So what issues are we looking for there? Only discuss if they apply. Impossibility, impracticability, frustration of purpose. These all cluster, so to speak, meaning they usually are all at issue at the same time. Make sure you do separate IRACs for each. Do not miss these very significant issues. What else could come up here? Well, really, those are the main excuses to non-performance, so you don't have to worry about too much else. As we get out of step 5, we are now in step 6, and this is where we want to be at, and that's breach. We're always going to go into breach. Breach is always going to be at issue. We have to determine what kind of breach we have. So there's a number of different breaches. Number 1, anticipatory repudiation. This is a major, major issue, and I can't tell you how many applicants miss this issue. Anytime in the fact pattern that you see a party that is communicating in some form or another, I might not perform, I may not perform, then you want to bring up anticipatory repudiation. Now, if you know the rule for AR, which I'll refer to it as, then you know that that communication not to perform must be unequivocal. So somebody's saying, the computer programmer saying, I don't think I can give you all 4 by May 15th. I'll do my best. That's not necessarily unequivocal. But don't pass that communication and go, that's not anticipatory repudiation. That's not met because we need unequivocal communication. Still make sure you talk about it. AR can be a 10 to 15 point issue, and make sure you do not miss it, because if it is met, it is your way to establish breach by a non-performing party. And is breach major issue, okay? So we have anticipatory repudiation. Make sure you give the remedies in your rule statement, which I have given you here in your approach, to the non-breaching party. Make sure you give your remedies to the non-breaching party in your rule statement. If we have an anticipatory repudiation, then we have breach, and now we can sue for damages. There are also UCC warranties. Remember in part 1 I told you about that February 2016 contracts essays? This was one of the first time these UCC warranties were tested, and a breach of any one of these warranties will be a breach of the contract and your way to prove breach. So make sure you reference that essay, but let's look at the warranties, because a lot of applicants missed those warranties. Seller warranties, any one of the 3 warranties below are grounds for arguing breach in a UCC agreement. We have an express warranty, an implied warranty of merchantability, and implied warranty of fitness for a particular purpose. Make sure you go into all 3. If, let's say, in that fact pattern you're going to look at, it was about surfboards, and the surfboards there was a actual material, I believe it was an epoxy. I don't know if I have the facts exactly right, but I'm pretty sure they're pretty accurate. Where the epoxy that needed to harden to create the surfboards, it wasn't hardening. So therefore there was a potential defect. Now we're not in product liability, so don't get all messed up there, but there was a potential defect in the hardening of the product. And therefore there was a breach of one of these warranties in how they portrayed that the epoxy was going to be able to be used for a particular purpose in a particular way. There was an express warranty there as well. So that was major in this essay. You could not have passed really without going into the warranties, assuming that maybe you hit everything else. But the point is that you want to be on the lookout if you're in a UCC essay for warranties. And if you don't have an anticipatory breach or UCC warranty issue to prove breach, then you're in just good old breach, and you have to determine whether or not it is a major or a minor breach. Remember that if the contract has been substantially performed, which means anything more than 50% of that contract, so half the house has been built, maybe there's an argument for substantial performance, which is a minor breach. It's a minor breach, substantial performance, so you'll identify it as such. Don't forget to really hash out breach. Breach is a major issue. You want to pick up some analysis points there as well. Now, don't forget, and this is, I have to label it. This is step 7. Step 7 are your remedies. Now, I cover remedies thoroughly in the remedies approach and material, so I'm not going to spend too much time on it right now. For purposes of part 1 and part 2 of contracts, we're dealing with the formation, the essence of the agreement, and then we're going into what happened after that agreement. That's what those types of essays are set up to do. However, even in those scenario 1 and 2, okay, formation and more steps 4 through 6, we're always going to consider our damages. Now, in remedies, I'm going to teach you, okay, and if you watch that video, I will teach you when to know you are in a full-blown remedies question, where really steps 1 through 6 are not really that relevant, maybe just a little bit, because in that you're going to want to get quickly into your remedies. And I'm going to tell you and teach you how all these different calls of question look, because it can be a little bit tricky to know how much time you should spend on certain remedies. They also sometimes will ask about the defenses to the remedies. Usually those are dealing with the legal and equitable defenses, and again, that has to be covered in the remedies section to make the most amount of sense. But for purposes of today, let's just go through a few of compensatory money damages. By the way, compensatory and money damages mean the same thing. They're synonymous. And these are the ones I always want you to go into, regardless of what type of contractual scenario essay you are in. Those are expectancy damages, where you would have been if the contract was really performed, reliance damages, incidental, and consequential. I want you to always consider those 4 damages, always, and separate IRACs always for your damages. Expectancy, reliance, incidental, and consequential. Others that could be at issue: restitution, Liquidated damages, they would have to give you a liquidated damages provision. They don't really do that a lot. Mitigation duty. Mitigation is something the bar really likes. They want to know if a party, let's say there's a requirements contract where you have purchased all of the tomatoes to make your famous tomato sauce, and the farmer cannot produce the tomatoes. Well, you have a duty to mitigate. You have to go find another farmer that can actually produce those tomatoes for you. A scenario like that, make sure that you identify the mitigation duty. And we have specific UCC remedies, and then of course the big equitable one of specific performance that goes with unique goods and unique items, and that is covered more in, of course, the remedies discussion. So I want to just give a little overview before we conclude. I'm going to put my paper down and just talk to you a little bit again, just so we really hit this home. We have 7 main steps. The first 3 steps are applicable law always. We're always going to go into applicable law. Then you're going to UCC or common law predominant intention factor test, only if at issue that test. Then we're going to go into formation, 2 main scenarios. First scenario, the facts tell us we have formation. We're getting to step 4. If the facts don't say we have formation met valid contract, written contract, then we're going to stay and we're going to really fledge out formation, offer, we're going to organize per communication, acceptance, potentially organize that per communication as well, consideration, if it fails, promissory estoppel. If formation fails, we're looking at quasi-contract. Don't forget that important equitable doctrine. After we get out of formation, we're looking at the defenses to formation in scenario 2, and we are really going to pay particular attention to the statute of frauds and exceptions to the statute of frauds. We also have a list of other defenses. We get out of step 3 and we find ourselves in step 4 eventually, regardless of the scenarios that we started out with. And when we start step 4, we're initially asking ourselves, have any of the terms of the initial contract in steps 1 through 3 been changed? Is there any potential change that we can argue for? And we're looking for a number of issues there as well. As we get out of step 4, we pretty much know what our terms are now. We get into step 5, and are there any excuses to a potential non-performance of a party? If there are not any of the 3 main excuses, then we get to breach. Anticipatory repudiation as a major issue that comes up. We're always going to give the remedies to the non-breaching party, and don't forget to have that unequivocal language in your analysis. They're really going to want to see that. Good analysis there and good points to be made, or to be had, excuse me. Then we're going to get into potential UCC warranties if at issue. This is in your checklist, okay? If you don't have UCC warranty issues, you're in a common law agreement, let's say, then you have general breach, and you have to go into whether you have major or a minor breach, which minor would potentially be proven by substantial performance. That rounds it up, and then you find yourself in step 7, the last step, which is remedies. We didn't cover a lot of remedies in part 1 or part 2 because that is left for the remedy section. But of course, there are compensatory remedies, as I said, I always want you to go into, and then our big one being specific performance as well. So make sure you spend time with both parts 1 and 2. Make sure you issue spot essays that really can be identified as both parts 1 and 2, and you understand how to issue spot, especially the issues that I've said not to always discuss, but to consider. Have a great day, and I'll see you in the next subject.